morning. May I have a charge sheet? Or at least... You may proceed to put us on record.
Mr. Court pleases, today is the 7th of October, 2025, in the Magistrates Court, sitting at JP Karwahe Street, in the matter between the State and Immanuel Mulunga and 14 others, case number 854 of 2025. Before the court is Cornelius Willemse, who is the applicant in these proceedings. Presiding officer, Ms. Moharukwa, for the state, Meili Lungwe, for the accused or the applicant, Mr. Isaacs, assisted by Ms. Ipinge, matter before this court for the submissions, closing submissions in respect of the bail application, and we are ready to proceed.
May please, Your Worship, I do confirm my appearance on behalf of the applicant in this matter, duly assisted by Ms. Ipinge in this matter. We are equally ready to proceed.
You may proceed.
Thank you, Worship. Your Worship, we filed our written submissions as instructed by the court. I do not intend to repeat each and every single word in the written submissions and will try to highlight some of the aspects that I want the court to take note of. Just to start off, the applicant in this matter is charged with 10 counts ranging from fraud, theft by false pretense, charges under the Act, Anti-Corruption Act, as well as the failure to pay tax. It is common cause that the accused person, now the applicant, was arrested on 8 July 2025 and now seek seek bail to be granted to him. The state opposes this application and cited 5 grounds of opposition. Your Worship, it is obviously tried law that when it comes to bail application, we refer to the landmark decision of S versus Atchison, which is quoted in my written heads on page 2, where some questions the court need to address when it comes to bail application. The all-encompassing question that the court needs to address is whether or not it will be in the interest of justice, or whether or not the interest of justice will be prejudiced if the accused person is granted bail. That is referred to in my written arguments on page 4, head note number 4. That is stated in the case of S versus Pinero. It is also tried law that our courts, due to the fact that that is infringement on your right to liberty, would lean in favor of bail, unless it is shown that it will not be in the interest of justice or will be prejudicial to the interest of justice. The applicant in this matter testified and put sufficient factual material before this court to show that on a balance of probability that he will indeed stand his trial and therefore not abscond. I refer the court to the personal circumstances of the accused, the applicant in this matter, that he was, or is rather, born in Namibia. That is undisputed, specifically in Keetmanshoop. He has obtained some educational qualifications in Stellenbosch and London, and his most recent address at the time of the arrest was in Windhoek. I pause here to already indicate to the court that obviously in the Atchison matter, one other aspect need to be addressed by the court is how prejudicial is the incarceration or continued incarceration to the accused. It was the testimony of the applicant that at the time of his arrest, shortly thereafter, he immediately suffered prejudice in the sense that the landlord cancelled his rental agreement. Furthermore, we heard testimony that tenants from his flats in Rehoboth refused to pay after his arrest. That in itself already shows to the court the prejudice the accused person suffered, and that is at the onset of the arrest. Now, it is common cause that the applicant has 3 daughters, 2 of them currently studying in South Africa, and it is his evidence that they are only studying in South Africa and that they stay with the applicant's now ex-wife. The only child that is currently staying in South Africa is his eldest daughter that is staying in Paarl in South Africa, Cape Town. Now, his immediate family, it is common cause, is his mother, as his father passed away, as well as his other 2 siblings, or rather his siblings, that is a 40-year-old brother, and 2 sisters that are born in Namibia. All of them, including the mother, his mother resides in Namibia. So it is without a doubt clear that his emotional roots, as he stands today here, are rooted in Namibia. Although he has dual citizenship, what is the residue of his emotional roots consist of a cousin or cousins and distant family. So in comparison, the people close to him, i.e. his emotional roots, there's no doubt, so there should be no doubt, is deeply rooted in Namibia. The second aspect of his bail application in terms of his roots are the property. Obviously, the court must consider in terms of his property as to how deep his roots in terms of finances or business-wise. The evidence is clear before this court that the majority of his property is in Namibia. It consists of a 3 movable property, namely the flats in Rehoboth, a farm, 2 farms that he currently owns. The 1 farm is bank financed. If the court compare the property that he has in South Africa, the court will find that the only property currently registered and or owned by the applicant is actually the vehicles, which are financed by South African banks. Court will remember that to a question by my learned colleague, why hasn't he transferred those vehicles to Namibia? His answer was that because it's financed by South African banks. He also, in South Africa, has what they refer to as a timeshare. Now, I think there's some confusion as to what a timeshare is. Timeshare, you can own the interest for a certain period. It consists of an immovable property that you have access to as testified by the applicant for a certain period of time, 7 days per year. So it is not a property registered. He cannot sell the immovable property attached to the timeshare. So to say that the applicant has immovable property in South Africa would be misleading. There is evidence that was placed before this Honourable Court that the two immovable properties that he had was sold in July and September. Now, what I find disturbing, Your Worship, is that my learned friend on 10 September 2025 put it to the accused that you still own this property and it's registered in your name. That is false. That was a misleading form of cross-examination. The prosecutor did not provide any proof that these properties are registered on the 10th of September 2025 in the name of the applicant. It therefore means that the emails that is provided, and the court will see, the emails that are in front of court refer to the very same law firm which my learned friend has cross-examined the applicant. So there can be no doubt in this court that these immovable properties are no longer the property of the applicant. My learned friend also tried to convince this court that the email was sent in September. So therefore, by September, the property must have been in his name. But the email sent by the very estate agent, which the applicant testified, was handling the property, shows the negative of that. After all, Your Worship, these properties in South Africa, i.e. the vehicles and the timeshare, there's no evidence before this Honourable Court that these properties were indeed bought by the so-called bribes received by the applicant. It would be misleading, Your Worship, if a submission is made that the applicant rents out this timeshare. He said if he testified that if he can't use it, he sells it. But it is not property in a true sense of the word. So timeshare provide a fixed period right and does not constitute a substantial or transferable immovable property. It is quite clear that at the time of the arrest, the accused person, now the applicant, has voluntarily submitted to the ACC, the Anti-Corruption Commission, his 2 passports, which are currently still in the possession of the ACC. One of the factors that the Atchison case tells us is that the court must also consider whether there was an extradition arrangement between this country where the applicant is appearing and the country where it is alleged he will be fleeing. It was confirmed, and I think the court can in fact take judicial notice of the fact that between South Africa and Namibia there exists extradition treaty. When the investigating officer was questioned about this, he came up with a bizarre reference to the Clearing matter. It has no relevance in this matter. He wants to tell the court that, look, even if we have a treaty, people can still run away. But in the Clearing matter, he was not on bail. There was no conditions attached for him not to run. He decided on his own to leave the country. The converse of that is that the applicant, despite knowing that there were cases registered against him, elected to remain in Namibia. In fact, he went so far as to acquire immovable property. So it is clearly distinguishable, the Clearing matter, as the investigating officer wants this court to take into consideration. It has find no relevance in this case. So, to conclude, Your Worship, how deep is the applicant's roots in Namibia? We have proven that emotionally it's in Namibia, property in Namibia. He has provided his passports to the ACC. So I submit that on the evidence before you, the court cannot but find that the applicant has made out a case that he will not abscond. Now, the second aspect rather, is the prejudice that is suffered by the applicant. It is undisputed evidence before this court that the applicant's continued incarceration would cause big financial harm. The court heard the evidence of the applicant that most of his property are bank financed. By logic deduction, and it was also testified by the applicant that if he does not work and remain in custody, he will lose the 2 farms. He will also lose the Reebok flats because they were given as collateral to one of the farms. So even that the property is paid off in Reebok, he also stands the chance of losing that property. In addition to that, he will lose the movable property because these cars are also bank finance. And if you don't pay the bank is coming after you and you will lose that property. So, and the prejudice is even more grave in his situation because the court will remember that the last farm that he bought, now valued at 13 million, he said, I don't have pension like other people. That is my retirement package. And if you take that farm away and all other property, everything that the applicant has done through his life in terms of business is gone. So the prejudice is not perceived. The prejudice in the applicant's case is real. The court then has to deal with the grounds of objection by the state. The state's first ground was the risk of abscondment. The applicant said this, Your Worship, and unfortunately want to quote this. Your Worship, I have no intention of absconding. I've been living in Namibia since 2006. I've built my business here, invested in property, and I've recently bought a farm where I plan to retire. My children are studying and intend to live here. I'm well known in both Namibia and South Africa. Running would only worsen my situation. I've known about this investigation since 2023 and remain in this country I want to clear my name. Interesting enough, when I posed that question to the investigating officer, the applicant says he won't run, he wants to clear his name. He didn't even answer that question. Very evasive. In fact, most of the answers given by the investigating officer were evasive. Never a straight answer to a simple yes and no question. When people are storytellers, they intend maybe to hide something. Because what other conclusion can this court make that if you evade a simple yes or no question, that you're hiding something? Now, my learned friend has indicated to the court that there's a risk of abscondment, a serious case. In terms of the law, I don't know why prosecutors usually do this, but in terms of the law, your seriousness of your case, strong case, these are two factors that our courts take in consideration to pinpoint to abscondment. But I see they are being treated, they've been indicated as different grounds. But I'll try to address them either individually, if I can, or collectively. Now, what is the state saying? The state is saying, look, our biggest fear is the applicant will run. Why? Because he's got dual citizenship. He was difficult to trace prior to arrest. And he's got property. His property in South Africa. He's got bank accounts in South Africa. There are no conditions that can prevent him to abscond. And then, in another attempt to taint the applicant as a runner from justice, the escape plan. But I want to deal with the escape plan later. These are basically the factors that my learned friend set forth to convince this court that the applicant will abscond. I've already dealt with the issue of the property. The bank accounts were explained. It is not sure, it's not clear why conditions and what type of conditions cannot be policed or imposed to curb this fear. I'm in the dark with that aspect. Now, a lot will be said today in court about the dual citizenship of the applicant. I want to refer the court to the case of Bolter versus State. I quote that on page 11, paragraph 33. Oh, sorry, page 9. Sorry, Worship. I think I've made extra notes on mine. But it refers to the Bolter matter. Footnote 14. Yes, footnote 14. It says, in bail inquiries, it is the duty of the court to conduct a thorough risk assessment by looking at the whole spectrum of factors for and against granting of bail as opposed to one-sided approach. I'm sure my learned friend will try to drill this dual citizenship as the main reason why the state thinks that the applicant will run. That is clearly not the legal approach. But by the way, Your Worship, Mr. Bolter was faced with a very serious offense, that is murder. But he doesn't have dual citizenship in Namibia. He's a foreigner. In fact, he's a billionaire. He has the means to abscond any given moment. But the court found that because he has got property, also here in Namibia, fixed property, immovable property, that simply because you've got money doesn't mean you will run. Now, if you look at the Bolter matter, you will see that the application in Mr. Willemse's case is that he invested his life in Namibia, and it is submitted that he's not likely to abandon his properties, his business or his family, all of which, for the exception of two bank finance vehicles and a timeshare, that he will not leave his wealth or ties in Namibia and run. I want to refer the court to footnote 19. It's also in the Bolter matter. I want to read it out, and I quote, "Another misconception is that being the bearer of a foreign passport automatically makes you a flight risk. Again, it's not as simple as that. It must not be understood to say that the peregrinus is not entitled to bail by any circumstances or in favor of detention without trial." We know that in the case of Mr. Willemse, he possesses a South African passport, but that in itself cannot convince this court that he will run. If the court look at holistically what other factors keeps him in Namibia, I submit that the court must, with respect, come to the conclusion that having a dual citizenship does not make you a flight risk. In the Bolter case, it was also indicated that, and that's what I'm saying in terms of conditions, where my learned friend says there's no condition that can curb anything. While in the Bolter case of a billionaire charged with a serious offense, who is not a citizen, born citizen of Namibia, the court was of the opinion that a bail condition such as passport surrender and the reporting can adequately mitigate that concern. The same would apply to Mr. Willemse. If the fear is really that you have two passports, the passport is already there, so no need for a bail condition to surrender, in a reporting condition. In that case, it says that it can adequately mitigate that concern. I submit that the authority quoted make it clear that a decisive question in terms of the applicant is not his foreign connections. The question is whether or not he will stand his trial. And as I've indicated earlier, Your Worship, this case against him is not new to the applicant. 2023, in fact, there was a criminal case opened against Mr. Willemse in 2024. Did he run? Well, he had the dual citizenship already in 2024. He had properties still in 2024, because the property was only transferred in 2025. He had everything in South Africa, but he didn't run. He's here. Another notable judgment that I want the court to consider is the one of S versus Noble. It's not in my written arguments, Your Worship. S versus Noble and another, bracket CC 10/2020, close bracket, open bracket 2022, NAHCMD, 25 August 2022, where Judge Sibaya on 15 September 2021 granted Meremoto bail to accused number 2, Mr. Azar, who was a South African citizen not a dual citizenship, a South African citizen. So it's not foreign to our courts to grant people that are not from this country bail. It really depends on the circumstances. So dual citizenship can never be a reason not to give bail. The next aspect is that I want to deal with is the issue of the risk of interference. Just before I step off from that point, you also will remember the testimony of the investigating officer. It says that I have intelligence that the applicant has property in South Africa. But the intelligence could also mean, because it's not verified, can also mean he doesn't have. So for any person in this court to make that allegation that there's immovable property in South Africa is misleading this court. Also interesting enough, during cross-examination, the prosecutor put it to the applicant. But Mr. Willemse, those butcheries that you claim, that business butcheries that you claim you sold, it's a lie. You still have, they're still in your name. And wonder by wonder, when the investigating officer come and testify, he was totally silent on that. So I don't know on what basis my learned friend has put that to the applicant. Because surely the only information that my learned friend can get must come from the investigating officer. We know that the PG office don't investigate. So it is just alarming to notice that some cross-examination questions were put to the applicant, knowing, hopefully not knowing, that that will never become and testify. And even worse, when I discuss the issue of escaping, the court will see that it was a travesty of justice. During cross-examination, what my learned friend put to the applicant, what the investigating officer will come and say. But I will deal with that when I come to that. So, the next ground was the risk of investigation and witnesses. I will not deal with the witnesses, Your Worship, because it seems to me there's not a ground, but I just want to, I did that just for completeness sake, so I will not deal with those ones in terms of reference or interference with witnesses as stated in my written arguments. The next question, or the next ground, that my learned friend dealt with is the issue of the seriousness of the charge and strength of the state's case. One thing that I've picked up from the investigating officer is that he doesn't want to talk about specific offences. All that came out from his testimony is conspiracy, 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 conspiracy. Even so that I had sometimes, while he was testifying, I have to remind him that he forgot to mention his song that he sung in terms of conspiracy. But the court, in dealing with this bail application, must deal with all the charges. That is what the state is asking you. He says that the seriousness of charges, I would assume, it means more than one. But the charge that the investigating officer concentrated on, basically, was the conspiracy charge. It is trite law that standing alone seriousness of a case is certainly a factor, but not the ultimate factor to refuse or grant bail. Otherwise, it's anticipated punishment. I'm also alive to the fact that bail applications is not a trial itself. But the state cannot sit back and make inferences and draw conclusions, as we heard the investigating officer did. The state must prove, it must demonstrate through credible evidence the strength or apparent strength of the state's case. That is the law. So simply to draw conclusions from money is paid, so from this company and to cipher through these companies, it's bribes. That is not allowed. I must admit that if the court has regard to the evidence of the investigating officer, that one thing is certain, there's no direct evidence, if one has regard to the charges, that the applicant received money from Enercon or from Irongo. There's no direct evidence. That is clear. So, because of the movement of the money and landed in the account, personal bank account of the applicant and one of his companies, Parkwood, the state is asking this court that in itself is a conspiracy. And once you find there's conspiracy, it means that all other charges is a prima facie case, because your conspiracy charge says that you've committed fraud, theft by false pretense, and money laundering and the like. I submit that if you look at the time of the arrest and you look at when this case was started to be investigated, according to the investigating officer, February 2024, sorry. And look what he tells the court when he was asked. These charges are only preliminary, Your Worship. We are still continuing with investigations and further suspects to be added. Since 2024, the ACC has been investigating this case. The Namibian police, since June 2024, has been investigating this case. Now, for the investigating officer to tell the court today, or during his testimony in September, say, well, it's still preliminary. Yusuf, that's why an applicant can be kept in custody because of the incompetence of an investigating officer. Look what he says about the IO. He says about the alleged payments, tracing of payments. We have not yet concluded tracing all the funds, and all the statements from the banks and witnesses are in. The matter is still under investigation. Come on, yours. Really? With the mighty ACC officers, I think he said 9 officers, 9 people were investigating this case. He comes to court and tells the court, well, it's just preliminary investigations. That is absurd. And then he says, when I ask, what's the proof that you intend to tender? He said, we cannot prove all the evidence at this stage, as it may jeopardize ongoing investigation. The docket is not complete yet. It's unbelievable. So, it is submitted that the arrest, the ACC simply arrested the applicant to complete investigations, and that is not allowed, as far as I know, in the Namibian law. even say the court find that indeed there is a strong case against the applicant, I want to refer the court to the case of S versus Santos, that is on Santos versus the state, that is footnote 31, Your Worship. He says that, the case says the following. The magistrate did not consider granting bail with conditions despite the applicant's undertaking that he is prepared to adhere to it. The fears expressed by the investigating officer in relation to money that could possibly be moved were unfounded, as already pointed out. Despite there being a strong prima facie case, it was wrong for the magistrate not to consider bail with stringent conditions, and it's a misdirection and wrong. We find that the applicant be a good candidate for bail with stringent conditions to curb the fear of likelihood of abscondment. If you look at the heads of the written submissions by my learned colleague, he does not even address conditions. Nowhere did I find that any trace of discussing whether or not conditions will be helpful or not was addressed by my learned friend. For the court not to consider the conditions would be a misdirection. Now, if you look at the strong case of the state as alleged, I want the court to compare that with the evidence of the applicant. The state is saying that you receive money, around about 1.1 million, 1.1 million from ECHO, from Quality Meat Supply, as well as Enercon trading the 1,040,000. So based on that, the state is saying, because assets were sold and the money filtered through to you, we are saying that there's a conspiracy and you receive a gratification. The applicant did not simply offer a denial. When he testified, he informed the court, he explained to the court rather, the existence or the reason why this money was paid. I want to deal with Parkwood first, where the applicant testified that, and produces, by the way, an invoice reflecting that payment. When I cross-examined the investigating officer, and his answer was that I cannot dispute or deny the authenticity of the invoice. Once he said that, it means, if one thinks that our courts lean in favor of bail, it means that the only credible evidence before you is that of Mr. Willemse in respect of that invoice. It cannot be disputed. It's before you. The state, on the other side of that coin, is saying it's conspiracy. No real evidence except for flowing of money, but the applicant gives this court real credible evidence to explain the payment. So as it stands, what the court have in front of you, Your Worship, is an explanation of that money. The state could not lead any rebuttal evidence to rebut that invoice. The second aspect is the one where he received money directly in his bank account. His explanation was as follows, that it was because he had a business relationship with QMS, and that he sold meat and game. My learned friend has gone to lengths to try to convince this court that can't be true. He started off his cross-examination and says, where's the moving permit? Where's the invoice? But Mr. Willemse, if you look at the amount, it's a lot of animals. And what did the applicant do? He provided the court with evidence of these animals. The moving permit has no legal relevance in this. I say so for the following reason. In fact, it was conceded by the investigating officer that when you sell carcasses, you don't need a permit. You need a moving permit if you sell live animals. It is undisputed, or it cannot be disputed rather, that the applicant testified that he sold carcasses. There's also, if you look at the bank statement, the reference there too. And therefore, the state cannot rely on the fact that there's no moving permit to say his story is not true. The state can also not rely on the fact that if you look at the amount, it's too much animals, because he had the herd statement. The only thing at this point that the applicant does not have is the actual invoices. But what does the state have? A theory, inference, speculation. And he informed the court that I'm in custody. I've sent people to look in the boxes. But remember, the applicant, if you look at the traveling of the passport, he was 10 days in Namibia, ACC arrest. ACC didn't go to Mr. Willemse. Mr. Willemse, I see there's transactions here from QMS. Can you provide us an explanation? No, they did not. The mighty ACC decided 10 days after the applicant arrived in Namibia to arrest him. Didn't ask him to explain. Now he's in custody. What do? They take a laptop, which can also provide the court possibly with evidence of the transactions. The applicant has asked, please give me access to this laptop. Look at the prejudice it causes the applicant by not providing access to the laptop. And they stand behind the dock and says that we have a strong case. There's no strong case here. My learned friend, in terms of the bribes, has gone through lengths. I was, at some point, Your Worship, I wanted to say, maybe we can just agree that these were the deposits, but he took on every deposit. This 18, this 20, 80, 20. I think it's maybe, I can't remember. He says it's the bribes. The state says so. When the investigating officer come and testify, the whole story changed. I was taken aback with this answer. I didn't say it's bribes, but it's flagged. There's a red flag on that payment. That is not the stance the prosecutor took. The prosecutor said these are bribes. They've not proven, there's not a shred of evidence that these monies were paid as bribes. In fact, the investigating officer distanced himself from that. Now, I don't know, my logic is that if something is a red flag and something is proof of something, I don't know which one is stronger. I would assume if you can prove something, it is stronger. So where's the strong case of the bribes? Where is it? In addition to that, my learned friend wanted to create this impression by painstakingly taking us through his bank statement. But the bank statement also tells another story. My learned friend is so selective in picking up this deposit, but when, during re-examination, it was shown that, in fact, prior to July, this was the trend in the bank account. Why? Because it confirms the version of the applicant that he sells cattle to informal markets on a cash basis. So the bank account actually confirmed what he's saying. So I submit that my learned friend's admission that those were bribes for the fuel supply to Irongo is baseless, with no merit. Of course, the IO says he cannot say that. It's red flagged. Don't know what that means, or maybe of concern. But does it make it a strong case? I submit not. One of the grounds, just to conclude then, therefore, I submit that on the evidence before you, Your Worship, that the state did not make out a strong case for bribes, as it is the basis of the charges. He didn't steal any money. Before I step off to the public interest, my learned friend also, to the investigating officer, testified, rather submit before court, that there was some sort of fraud, and Mr. Willemse was instrumental in the buying of these assets. Court must remember a few things. One, the buying of the assets, the investigating officer says that was part of a conspiracy. All right? So, in fact, he says the conspiracy commenced in October 2021. So there's a conspiracy that started in October 21 that gave rise to session agreements, gave rise to fuel purchase agreement, gave rise to the asset purchase agreement. His theory, through the IO, is that that is the conspiracy. But if you look at the evidence, the investigating officer conceded October 2021, in terms of the session, the conspiracy, he cannot link the applicant. So October is out. Next question I ask, because obviously October gave rise to the session agreement. Was he involved in the session agreement? He cannot say. So session agreement is out. Then I ask, okay, was he involved in the fuel purchase agreement? He said, no, there's no evidence to that. The only reliance my learned friend is placing on the conspiracy theory is the asset purchase agreement. Now, where was the applicant all this time when the conspiracy was picking up? Nowhere to be found. And he explained why he was involved in the APA. He informed this court that he was asked for his assistance due to his massive experience in the fuel industry by the MD, the managing director. And remember, Your Worship, when I asked, can an MD give instructions to Mr. Willemse, who is his subordinate? That was a concession he made. So that's why he's involved in the APA. So my learned friend is left with an agreement that he now argues, or probably will argue, that that forms part of the conspiracy. But the court must remember, Mr. Willemse signed on that memorandum. And he says, this is the reason why I signed. The numbers make sense. But all the other boxes were ticked. Proof of ownership, whether it makes financial viable to buy it, budgets, all those boxes were ticked. Now my learned friend is saying, or the IO is saying that, listen, before he signed the invoice, he was supposed to make sure budget verification. It's not his job. He says, well, it's in the policy. Where? I ask where. Well, it's in the policy. These speculative, evasive answers that the investigating officer gives put a big taint on the argument by the state that he has a strong case. It was the court cannot help but find that Mr. Willemse could not have been instrumental in the APA. In fact, the buck stopped with the MD. He cannot instruct the MD to sign. And by the way, that project did not fall under his department. Hence, his limited involvement on instruction of the MD. My learned friend, when he deals with public interest in the administration of justice, I've had a quick look at his written arguments. He says that these are public funds. I think I missed that testimony by the credible evidence that is public funds. In fact, his argument has been crippled by his own investigating officer when I asked a very, very, very important question. During cross-examination, I posed this question. The assets that was bought for 53 million from Enercon, that money, did it come from Namcor Holding? Or did it come from Namcor Trading? Or is it public money? His answer must have also surprised you, because he now says that, no, he didn't say it comes from public funds, it comes from their own operation. So where on earth does one come up with an argument that it involves public funds? It does not. We know for a fact that Namcor Trading operated on its own, generated its own income, pays its own debts. So, to say it's public funds would be incorrect. So one of the legal principles that's been decided over a number of years is that it is not, when you look at public interest, the court is not allowed to only look at it from the perspective of the state. In terms of, it is right that it will not be in the public interest also if one keeps an applicant in custody where it's proven that he will not abscond. I want to repeat that. Because of the wide definition of public interest, it will also not be, because clearly Mr. Willemse is part of the public, it will not be in the public interest to keep an applicant in custody if it's proven or shown that he will not abscond. I just want to refer the court, I've made a note here, in terms of the public money. The investigation officer says that when I asked him about whether it's public funds, he said he never testified that one of the other grounds which my learned friend is depending on and hoping is that the outstanding investigations and this court has not heard a single or thread of Mr. Willemse will interfere in investigations. He's no longer at Namcor trading. He left already 15 November 2023. He has no contact. And interestingly enough, when you look at the evidence of of the investigating officer, he says that the investigation is not complete because we have to analyze documents. Now, how does Mr. Willemse incarceration prevent him to analyze documents? The mighty ACC is saying, keep Mr. Willemse in custody because we first want to analyze things. There's no reason at all to keep Mr. Willemse, the applicant, in custody. The law is very clear on this. I'm referring to the case of Etchison, that is footnote 35, Your Worship. It says that dealing with temper of witnesses and interference, it says, and I quote, was there a reasonable likelihood that if the accused be released on bail, he would tamper with witnesses or interfere with the relevant evidence or cause such evidence to be suppressed or distorted? Before you, there's nothing. There's a speculation of some sorts by the investigating officer. On footnote 37, also dealing with the Etchison case, it says, and I quote, it appears to me that as applicant has thus far not interfered with investigations, the proper approach should be that unless the state can say there's a real risk that he will, not may, that he will interfere, there does not appear to be a reasonable possibility of such interference. Reading the, in addition to that, Your Worship, if you look at the case of Bennett, as I've alluded to early in terms of investigation, it says that, and I quote, this is on page footnote 38, and I quote, the constable says that his investigations are not complete. This is certainly not a reason in itself for keeping the accused in custody. The investigating officer will have to say why and how the detention of the accused will assist him in completing the investigation. That's the law. This question was asked by myself to the investigating officer. And again, one of the evasive answers, he just simply says that there's a fear. No basis. No substantiation in terms of his fear. But the law says you must tell the court how and why. Your Worship, I want to submit that it appears that maybe when it comes to further investigations, that my learned friend might try to convince you that he was actually referring to the time of the arrest. Because we know that a certain individual, Mr. Malema, disappeared from Namibia. Disappeared. It's not to take that I know that he went out of Namibia, but he is obviously, as they say, in the wind. That because there was a conversation between Mr. Willemse and Mr. Malema at the time of his arrest, that that means that he interfered. I invite the court to please go read that record. There's no evidence, and in the piece, that is the submission by my learned friend, that Mr. Willemse contacted. He called Mr. Malema. What he testified is that he received a call while the phone was in the hands of the mighty ACC, and people have been showing, look who's calling, look who's calling. So, by the time of receiving the call, that phone was already with the ACC. So that takes away the notion that he interfered. I must but stress this, that the state must give credible evidence on their grounds. They can simply not ask this court to make inference. They must provide credible evidence. They have the phone of the applicant since July. They could simply draw MTC records and come show to this court that there was a call made from Mr. Willemse to Mr. Malema. There's certainly, if there's a submission in this court, that there was evidence that the applicant called all other co-accused, meaning the Elindi brothers, Dunaiski and the like. If someone submit that in court, Your Worship, that is a serious misleading of evidence before you. There's no such evidence. Your Worship, I've in terms of the merits of the case against applicant, I've summarized that already. I will not repeat that. I just want to deal with the issue of charges. So, may I just quickly approach client?
You may proceed.
Thank you. Thank you, Worship. Just maybe before I address that issue, I just want to deal with the escape plan. I was surprised, Your Worship, to say the least, when reading the written arguments of my colleague, that he insisted that there is an escape plan. It was put by my learned friend that the IO will come and testify that there was an escape plan. When the investigating officer arrived in the dock and was asked about this escape plan, he distanced himself. He said, I didn't say that. Now I'm wondering, where did the prosecutor get that? Was this a deliberate, vexatious attempt by my learned friend to taint Mr. Willemse as a person they want to escape? Or should we lay it in front of the door of the ACC, because my learned friend must have get that information somewhere. So to put it to Mr. Willemse that there was an escape plan, and then being denied by the very same person that says he will come and testify that. Yusuf, I've never seen such unfair cross-examination in my life. And expected the accused person to answer to that. I don't know if you have had a look when that question was posed to the applicant. In fact, he was almost laughing, because it's laughable. My learned friend says that I will come and testify that the applicant was escorted by a private vehicle. We heard the testimony of Mr. Inambao. He never testified that. He said when he arrived there, he was in a police vehicle. Where did my learned friend get that? My learned friend says that I will come and testify that you were followed by this Mercedes-Benz. That was denied by the very person he said will come and testify to that effect. Where did he get that? More alarming, he says that at the hospital, that I will come and testify that the reservist was chased away when he was guarding the applicant. That was also denied. In fact, the IO have distanced himself so far from those allegations, it's laughable. And I submit, in fact, when I cross-examined the investigating officer, he says that because of the dual citizenship, there's a fear. There's always a fear. But was there an escape plan? To mention that in the written argument, Your Worship, it's disrespectful towards this court. So may I just take a 5-minute break, just for a bathroom break. I'm almost done. I'll be dealing with the charges and then I should be done.
Okay, we can make it 10 minutes.
10 minutes will appreciate it.
We will then proceed at 12 o'clock.
Thank you, Worship.
You may adjourn.
stated that it would also be against the public interest to keep the applicant in custody. I just want to give the court the case law for that. Is Jose Kamungura versus the state, Jose Kamungura and another versus the state. Case number CA 67/2001, delivered on 5 December 2001. Thank you, Worship. Dealing with the charges, Your Worship, I understand that the proposition of the state is that these are preliminary charges. I find it difficult to understand why this justification is there, because one, the accused person, or the state rather, opposes bail on the following. He says serious charges. That's one of his grounds for opposing bail. Now, if your charges, as it stands now, are defective, how does the court then come to the conclusion that they are serious? If you look at the testimony of Mr. Willemse, he said some charges are very confusing, Your Worship. Another charge says I must be present, being part of an asset acquisition, but the predicate cause was giving fuel. No, that doesn't make sense. That's confusing. So for my learned friend to hide behind preliminary charges, I say that that would not be justified because of the grounds of serious charges. What is also important is that the applicant was arrested in July. We are in September. My learned friend must have had the opportunity to correct those charges, the defective charges. But as we stand today, this court is being asked to make a fact-finding that the charges are serious. I submit that some of these charges lack clarity, and that in itself poses a risk to the case of the applicant. Now, if you look at the charges that the applicant is facing, in my written submissions, I have pointed out some of these charges that are defective. In fact, I started with the first charge, where it is actually a charge that consists of more than one element. So if the court, at the end of the day, make a finding that the charges are serious, I'm sure the court must have had regard to not only the evidence, but whether the evidence as testified support the charge. In my written arguments, I dealt with charge number 8, 12, 13, and 14. For the purpose of this submissions, I will not repeat what is stated in there. Safe to say that if you look at these charges, it is a guessing game in this court as to what are the charges that the applicant is facing. And if it's a guessing game, as to what these charges the applicant are facing, it would be impossible for this court to say these charges are serious, because it doesn't say the evidence is serious. The state is saying the charges, as they appear now, are serious. I further submit that, in conclusion, or before I come to that, during the break, Mr. Willemse alerted me on something that is also very crucial that I need to bring to the court's attention, is that, if the court can remember, there was the issue of the Heard statement, where my learned friend has cross-examined the applicant, say that you don't even have a statement in support of the contention that it's impossible to provide the number of animals. But what came out of court during this application is disturbing. In fact, my learned friend has vehemently objected against that statement. All in the meanwhile, while the investigating officer sits with it. Bishop, if that is not a distortion, or at least a concealment of evidence, then I don't know what. Because the court must remember, my learned friend is here to put facts before you. These facts must include, in all fairness, also facts that will assist the applicant. And by concealing that, I submit that the state already knew that Mr. Willemse had the capacity to sell animals, because he already had the Heard statement. The investigating officer also told the court, unfortunately, there's no column for slaughtering. It's irrelevant. Mr. Willemse is not the author of what the veterinarian or meat bot puts in there. So the absence of that column as to how many animals were slaughtered cannot be a negative inference drawn by the applicant, because that's the form. That's the Heard statement. It is not in my heads, but I want the court to refer the court rather to the case of R versus Rickert, 1994. Rickert, R-I-E-K-E-R-T, 1954, bracket A, bracket 4 rather, sorry, SA 5254, bracket SWA. In this case, it says, the public prosecutor does not only represent the interests of the Crown, but he also has a duty towards the accused to see that an innocent person not be convicted. Thus, it is duty to disclose, in certain circumstances, facts harmful to his own case. Unfortunately, that didn't happen in this bail application. But luckily, the applicant managed to obtain that Heard statement, proving that he had the capacity. So on that basis, I submit that the following boxes are ticked. If one has regard to the Atchison case, 1, did the applicant shows on a balance of probability that he will not abscond? That box is ticked. 2, did the applicant, on a balance of probability, prove to this court that he will not interfere with investigations? That box is ticked. Is the applicant facing a strong case? Unfortunately, that box cannot be ticked. what are the prejudice that the applicant will suffer for his continued incarceration. That box is ticked in terms of the prejudice he will suffer, as stated herein before. It appears that my learned friends say the public interest is funds and strong case. I've dealt with both of them. So, the conclusion that is not in the public of interest because of public funds and a strong case, unfortunately, in this bail application, cannot apply. The court must please allow me to address some of the factual allegations by my learned friend, where indicate that these funds were marked for community projects or welfare of the people. I don't know whether I was absent, but there's no evidence placed before you that these funds were earmarked for that. And if one follows the law, that credible evidence must be placed before you, then that is simply an argument, and it turns to nothing. It cannot therefore say that it's in the interest of the public, based on that the applicant needs to stay in custody. Finally, Your Worship, I want to submit that any residual fear that are still in the mind, or is in the mind of the court, can be cured with strict conditions. I therefore submit that the applicant discharge the onus to be committed bail with an appropriate amount. I see that most of the applicants has already got bail in this matter. It appears $50,000 million, with strict bail conditions, would be just and fair, and also fair in terms of administration of justice. Because you cannot keep a person in custody facing a case where he himself, through his own evidence, not relying on the evidence of the state alone, through his own evidence, has proven that the state doesn't have a strong case. Those are my submissions. If there's anything that the court wants me to specifically address, I would ask that the written submissions be received by this court to form part of the record.
The court has no questions. Thank you, Mr. Isaacs.
As the court pleases.
Mr. Mulunga, you may proceed.
Thank you, Your Worship. In response, I'll proceed as follows. Your Worship, we have also submitted written heads of arguments which I will revert back to after I've responded to the submissions by my colleague. But I'll start as follows to respond briefly to what has been submitted by my colleague. Now, Your Worship, it is trite law that what we are dealing with here is a bail application in which, as a starting point, the standard of proof is based on a balance of probabilities and not proof beyond reasonable doubt. That is number one. And secondly, we are also not dealing with a trial where an accused person is required to plead to the charges. And this is premised around the point of the charges as being weak or not in order, a point to which I'll revert back to, or I'll touch on in my submissions proceeding forward. Now, Your Worship, just to put things in context, I just want to touch on the following aspects. Yes, it is indeed true that there is Exhibit D, which is an email correspondence from Gravenstein lawyers, which are lawyers who are based in Cape Town, to which submissions were made to the effect that, well, from the reading of the email, the properties of the applicant before this court have since been sold. But we were accused, among other things, that it is misleading or is not the proper law to suggest, among other things, that these were public funds. But I'm just putting that in context also to say it is also wrong to suggest, as we have it here before you, Your Worship, that the two immovable properties of the applicant have since been sold. Because what we have before this court, firstly, is just the emails from the lawyers. The law of property is very clear that for the transfer of property, there must be a deed of transfer. So the question that has to be asked firstly is that, is there a deed of transfer before you, Your Worship, before this court? Absolutely not. There is no deed of transfer to show that indeed those properties have been sold to a specific person and when that deed of transfer was actually done. That is absent. And secondly, there is also not even a name, if I may put it as that, a name of the person who is alleged to have bought this property. That is absent. So can it therefore be said on the mere looking of the email that is attached as Exhibit D to the record that it is indeed true that the applicant has disposed of these properties that he owns in South Africa? The answer will be in the negative, that the property, as I cross-examined the applicant on the 10th of September, that our stance is that the property is still in the name of the applicant. And if one has regard to the testimony of the applicant himself, in fact, from my calculation is that the combined value, which I've also stated in my submissions, is that the combined value of these assets is approximately 4 million. And the money, or the proceeds from the sale of those two properties have also not been repatriated, if I may put it as that, to Namibia, where the applicant is actually staying at the moment. So to suggest that, well, the applicant's strong roots are in Namibia because he stays here, I submit that if indeed these properties have been sold, where is the money or the proceeds from that property? I would submit that the money is still being held in banks that are in South Africa, where the property is. Perhaps, Your Worship, it to be the opportune time for me to address the issue of the charges. I've seen that it's an issue that has been dealt with at great length. But I just want to put the following to court, that there are at least 3 questions that need to be put. I know I've touched on it in my preamble to the submissions, but firstly, Has the accused person been asked to plead to the charges in the bail application? The answer is no. Is this a trial? No, it's not a trial. What are we dealing with at this moment? We are dealing with the primary issues, that is the applicant a good candidate of bail? That is what we are seized with at the moment. So, are the charges as being alleged that the charges are weak or they are not so properly couched at the moment? We submit that even if the charges are not couched or drafted in the manner in which it is suggested that they should be, we are submitting, Your Worship, that these charges are strong as steel. In fact, if one has regard to the amounts that are mentioned here, these are not mere amounts that appear in every other charge, because if one has regard to the asset purchase agreement, 53,212,000, the credit limit that was exceeded in respect of Hirongo Petroleum, which we have seen from the document, is 266 million. So on those amounts, can one then say, well, these charges are not strong, they are weak charges? I submit not. So we are saying this is not the proper avenue to attack the charges, and technicalities at this stage should not be used as a backdoor approach to challenge the charges, or to say the applicant is a good candidate of bail because of the charges. We are saying that is another issue that has to be dealt with in another forum. Your Worship, I'll move on to the aspect of the head statement of the livestock, which was an issue that I actually dealt with the applicant himself. Firstly, there is the case of Ricket that was quoted, that a prosecutor should not conceal any information. I just want to put things in perspective that when we started with the bail application, because of the standard of proof that is required, and the standard of proof is moved to the applicant, who has to prove that he's a good candidate of bail. So that's why the head statement was not disclosed to the applicants, because we did not seek to use it at that moment. In fact, Your Worship will recall that the head statement was actually produced only in re-examination and not in the testimony of the applicant himself. So this goes on to show that we were not malicious in our presentation of evidence. In fact, if the applicant, in fact, produced those documents, he can actually be applauded for that he actually assisted us. Although we are saying, firstly, that the head statement does not say when the animals were sold, as he alleges that the huge deposits that appear on the bank statements as a result of the sale of the animals. That, unfortunately, is absent from that head statement. It does not say which animals were sold. So what is shown on the head statement is actually the animals that he owned, or that were at his kraal or at his farms. But what is absent on those documents is when they were sold. And secondly, if he alleges that, well, the money that appears on the bank statement, rather, yes, on the bank statement, is as a result of the sale of the animals, we do not even have a single invoice from the person that he sold those animals. We do not have a movement permit, if we can put it that way. There is no invoice from Quality Meat Supplies, which he says he was doing business with. So can it therefore be said that, well, the money that appears on the bank statement is as a result of the sale of the animals? We submit not, because that is just his mere say-so. And if regard is had to the amounts that appear on the bank statement, the amounts that I can remember, the 960,000 that appears that he received on 18 July 2022 in his personal bank account, the 150,000 that he received on the 15th of July, that is also not supported by any document to say, well, this money I received from Quality Meat Supplies, as it shows on the bank statement, I received it as a result of me having been in business with Quality Meat Supplies. Unfortunately, that is also absent. So we are saying that is just a concoction of something that he wants to fall back on, to rely on, to say, well, this money was not as a result of me having facilitated the asset purchase agreement, and to bring in the issue of the sale of the animals is just an umbrella, if I may use that phrase, Your Worship, that he just wants to rely on that so as to mislead the court. Your Worship, the issue of the timeshare that the applicant owns at Sun City was an issue that was also dealt with. Well, I accept that it is on for a certain period of time, but what we don't have here before court is that he has relinquished that timeshare or he has transferred it to someone, because it is being suggested that you own it for a certain period of time. But what we don't have before this court is whether he has relinquished his timeshare at Sun City. So as we stand here, we are still saying the applicant before court actually still has that timeshare at Sun City, which by extension we can say it's a property where he can generate income, just like the immovable property that he has in Cape Town. So we are saying, without any proof that he doesn't own this timeshare, we are saying, well, he still owns it as we are standing here. Your Worship, regard or reference was made to the Bolter case, which we also have read, but I have not referred to it in my submissions. But I must say the following. Your Worship, firstly, the Bolter case is distinctive from the case before court in the following aspects. Firstly, the circumstances or the facts of the Bolter case are different. Although it is said Mr. Bolter is a billionaire or whatever, but we are saying there is the important principle in law of individualization that if all cases are just dealt with in the same way, well, we accept that you can make reference to a certain case just to assist the court in arriving at a decision. But we are saying in the Bolter case, the court looked at different circumstances in arriving at a decision to grant bail to the applicant. In this specific case, Your Worship, firstly, I demonstrated during cross-examination the movement history of the applicant to South Africa, which shows that from December 2019 up until 19 June 2025, the applicant had traveled to South Africa at least 40 times. That is number one. Secondly, the applicant on record himself indicated that he started primary school in South Africa, secondary school, tertiary education, and also, in fact, even his first employment was in South Africa. So we are saying his roots to South Africa are actually more stronger than it is to Namibia. In fact, if I can be allowed to put the analogy of an amphibian, which can live both in land and water. In fact, the applicant can switch or move freely to South Africa without any difficulty or hardship because his roots are stronger there, as we are saying. He has property there. he faces serious charges here. He does not face any charges in South Africa. So the incentive to abscond from Namibia is actually very high. He can easily start a life there. That's what we are saying. Your Worship, reference was also made to the Noble case where Mr. Azar was granted bail in that case. But in the Azar case, or in the Noble case as it is called, it is important to note that it was during trial actually when the accused was granted bail in that case. And also, because consideration was made by the learned judge there to, after evidence had been led, and the judge came to the opinion that from the evidence that had been led at that stage, Mr. Azar would be a candidate for bail, and that's why he was granted bail. I was fortunate enough to have sat in those proceedings, and that is actually what happened. Your Worship, I just want to invite the court also to have regard to Exhibit F1, which contains the email that actually set in motion the asset purchase agreement. Now, Your Worship will recall from those documents that there is an email from the applicant before court to Ms. Dunaiski, in which he says, you can make our submissions to the MD so that we can be close to our goal, if I'm paraphrasing. But what is important is to say that the involvement of the applicant before this court in respect of the asset purchase agreement and the money received in his account shows that his involvement was not on a lesser scale, because this is substantiated by the amount that he receives thereafter after the signing of the asset purchase agreement. Your Worship will also recall that during cross-examination with regard to the fuel supply agreement of Erongo Petroleum, the applicant's answer with regard to when I asked him that, well, have a look at the credit policy, which actually governed the credit limit that had to be given to a customer of Namcor. His answer was that there was an anomaly. But when I asked him that, look, the credit policy is actually very clear. It says when a customer has exceeded their credit limit, they should be blocked. And the credit limit of Erongo Petroleum was at 10 million. But there is evidence before this court that Erongo Petroleum, despite having exceeded their credit limit, was still supplied fuel to the value of 266 million, as we have seen from the second bundle. So we are saying the involvement of the applicant actually shows that there is a strong case against him. And when regard is also had to the bank statement, specifically the money that he received after the fuel supply agreement was signed or the credit limit was exceeded, the properties, or rather the money that was being constantly sent to South Africa to a bank account that he has there, the property that he has that I put to him during cross-examination, in which a law firm by Norton Fulbright was used. In fact, his answer was that, well, no one is prohibited from buying any property abroad, so it was well within my right to buy property. We agree, but what our concern is, the money that he had used to buy those property was as a result of the money he was receiving from Erongo Petroleum as a result of him having facilitated the exceeding of the credit limit despite it being a governing tool. He actually went against the same governing tool that was supposed to guide him him and his applicants, co-accused actually. Now, there was also another issue that is actually misleading to say these are public funds, but I just want to put things in perspective, Your Worship. Firstly, we know that Namcor, Namibia Petroleum, the parent company, is a state-owned enterprise, and by that, it receives funding from government. So are its subsidiaries, because we are saying they cannot be a separate legal personality from Namcor Trading and Distribution and Namcor, because we have understood during the evidence that, in fact, Namcor Trading and Distribution would receive subsidy from government. So to suggest that, well, these are two separate entities, I'm submitting, Your Worship, that it's actually misleading the court, and that these are not separate entities that is being said. Your Worship, there is another aspect of outstanding suspects that still have to be arrested. Now, it is not disputed that Victor Simaneka Malima is on the run since this matter appeared in court. But what is of importance is the evidence of the investigating officer who testified that on the day, on the 8th of July 2022, when the applicant before court was arrested, at the same time when he was being arrested, Victor Simaneka Malima actually made a call to the applicant. And he was made to understand, that is the investigating officer now, that just after the applicant was arrested, Mr. Malema actually crossed over into Angola. And up until now, Mr. Malema has not been arrested. So we are saying there was a communication between the applicant and Mr. Malema, because just by extension, we know that Quality Meat Supplies, which was the financer of this whole case, Quality Meat Supplies was owned by Mr. Malema. He was the beneficial owner as per the evidence of Mr. Inambao. So we are saying the applicant before court has a good and strong relationship with Mr. Malema, because of all people, it can't be just by coincidence that at the moment that he's being arrested, then there is a call from Mr. Malema. And that's why up until now, as per the testimony of the investigating officer, is that that's why Mr. Malema is actually still on the run. And we are saying the applicant before court, due to his relationship also with Mr. Mulunga, who he had also called, according to the testimony of the investigating officer at the time that he was arrested, we are saying he has a relationship with the other co-accused persons. Now, Your Worship, I would just like to pack that and then move to my submissions, which I would not go into much detail, but in going forward, I will just be referring the court to specific pages. Yes. Your Worship, with regard to on page 2, which proceeds until page 3, I've referred this court to the Ngipunya case, which actually cements the notion that an accused who applies for bail bears the specific onus to prove on a preponderance of probabilities that the interest of justice permits his release. It goes on to further say that this means that an applicant must specifically make out his own case and not necessarily rely on the perceived strength or weaknesses of the state's case. And I'm saying this being mindful of the fact that it is being suggested that, well, look, the case that you have against me is actually a weak one. But Ngipunya case is actually very clear. It says in a bail application, an applicant cannot rely on the strength or weaknesses of the state's case. What he needs to do, rather, is to show that he's a good candidate of bail. And we've seen that the charges as they appear on the charge sheet have actually been attacked. In fact, there has been an onslaught on these charges to say, well, this amount, this stance, this one, but that is not what we are concerned with at this stage. What we are concerned with is whether the applicant is a candidate of bail. With regard to the applicant's case, on page 3, I've briefly touched on the circumstances around the applicant, and we are saying it is not prohibited for one to be a dual citizen of any country, but when one has regard to the Quetta case that I've referred to on page 6, paragraph 4.1.9, where it was stated as follows: the court will take various factors into account when considering whether an applicant has strong ties or deep roots in a country, and these factors should be taken together. No one factor can stand by itself. So this is what we are actually saying, that, well, it is not prohibited for anyone to be a dual citizen of any country. Neither does the fact that one is a dual citizen of a country, that aspect alone does not disqualify that person from being granted bail. But we are saying there are several other factors which have to be looked at. And in this case, the immovable properties, the 2 cars that the applicant has that are financed with banks in South Africa, the timeshare property that he has at Sun City, the 2 properties which, as I stand here today, that he owns in Cape Town. There are no deed of transfers. There has been no proof that these properties have been sold. His movement history to South Africa. All these factors, when considered together, we are saying, in assessing the risk of absconding, the likely degree of temptation to abscond that will face the applicant, Mr. Willemse, is very high. In fact, we have also been told that his children are also residents in South Africa. So we are saying, well, for him to relocate, there will not be an issue. Your Worship, on page 7, we deal with the aspect of the seriousness of the charges, which I've already dealt with when I responded to the submissions made by my colleague. But we invite the court to have regard to the bank statements that appear in the first bundle of the applicant, and also the second bundle, which also contains the bank statement of Parkwood Petroleum and Logistics, in which it is shown that specifically in Parkwood Petroleum and Logistics, an amount of 1,040,000 was received by the applicant. And we are saying, remember, Your Worship, there is an amount of 9.5 million that was received into the account of Eco Trading. And from that 9.5 million, an amount of 1,040,000 is the same amount that was, from that money, the applicant actually received that 1,040,000. And we know by now from the testimony of the investigating officer that Eco Trading was owned by Austin Elindi, who is also an accused person in the current case. So, in fact, just to put it in the words of Mr. Inambao, these are branches of the same tree, in that if one has regard to the interconnection or how interrelated these entities are, and the connection that the individuals that own these entities have with the applicant, we are saying there is a strong case because these people are interrelated and the applicant before court actually received money from that. And whatever he says that it was money from the sale of animals or specifically the 1,040,000, he says it was a cross-border thing, cross-border transaction that he had entered into. Unfortunately, that is the only receipt, or that is the only invoice that he showed, that he presented before this court. So if he was doing business with Eco Trading with regard to any cross-border business, why is it by coincidence that when the fuel supply agreement is being questioned, when the credit limits were being exceeded, why is it by coincidence that at the same time he receives that money into the bank account of an entity to which he has interest in? On page 8, Your Worship, I refer to the Gustavo case, which has actually stated that Section 61, which is a provision that we rely on in these proceedings, that bail should be denied to the applicant. But we are saying Gustavo case has distinguished, or actually has not made a distinction that, well, it is only in violent crimes where bail should be denied. But we are saying, from the reading of the Gustavo case, Section 61 should not just be confined to violent crimes. And in fact, Nyipunya also echoes the same sentiments in that monetary crimes and violent crimes can no longer be seen to be different in bail applications. And that's what we are saying. And in fact, in Nyipunya case, it is stated that whether the crimes involve public funds or a physical attack on a member of society, if the circumstances permit, the seriousness therefore must be taken into account when considering bail. So we are saying, if the court has to follow the dictum in Gustavo and Nyipunya case, Section 61 can not only be relied on in violent crimes, but also in monetary crimes, such as the present case. And these charges, which are listed under Part 4, Schedule 2 of the Criminal Procedure Act, the charges of fraud, theft, and conspiracy, are actually offenses in which courts, and I'm referring to the lower courts as well as the high courts, that the courts have actually refused bail on the reliance of Section 61, especially if those offenses are listed in Part 4 and Schedule 2 of the Criminal Procedure Act. And what we have here before this court, Your Worship, are those offenses which are fraud, theft, and conspiracy to commit the other offenses. Your Worship, I will conclude if the court just bears with me. But what I wanted to touch on is the issue around the asset purchase agreement. And with that, I would want to invite the court to have regard to the CAPEX budget, which is an exhibit that is before this court. In that, in fact, when I confronted the appellant during cross-examination, he was actually in agreement that from the document, it shows that the asset acquisition for 2022-2023 was kept at 25 million. And for assets above 25 million, they should have received board approval. But when context is made with regard to, firstly, the emails between the applicant and Ms. Dunaiski, the CAPEX budget, the schedule of authority, and the fact that there was no board approval to acquire any asset above 25 million, it actually shows that the applicant, as a member of the credit committee, actually disregarded the same policies that he should have followed, in that he went ahead with his accused persons, and they acquired the 9 home-based fuel stations, to which up until now, actually, Namcor has never taken ownership on. And interestingly, which is a red flag, is the fact that from the 53,212,000, we have heard from the testimony of the investigating officer that 35 million was actually again used or paid back to Namcor to pay back the debts of Enercon, which actually shows that there was actually a conspiracy to commit these offenses, in that things were not done by book at Namcor. The executives used Namcor as a cash cow to actually fund their luxury lives, and that can be evidenced from the bank statement of the applicant, where he had acquired several properties in Namibia, and I've demonstrated that there was a Mahindra pickup bakkie, a Land Cruiser, quad bikes, generators, and a lot of other properties that was bought as a result of him having facilitated the asset purchase agreement. And, Your Worship, there was also an issue of the memorandum between Enercon and the Ministry of Defense. I just want to highlight on that aspect that in terms of that agreement, Enercon could not sell the assets without having informed the Ministry of Defense in writing. And unfortunately, in this case, what we have here is that there was no notification in writing that was made to the Ministry of Defense. In fact, the Ministry of Defense was actually caught by surprise when the assets were sold. That also goes on to show that the applicant, again, as a member of the credit committee, he was supposed to question these transactions, alert his fellow members in the credit committee, and at least stop with the transaction of the asset purchase agreement. But he still went ahead and did that. Now, Your Worship, just to conclude, the most important aspect that we want to deal with is the reliance on Section 61, which deals with the interests of the public or the administration of justice. Now, what we have here is to balance the two things. Firstly, should the court lean towards the liberty of the accused person and grant him bail, or should the court then also consider whether the interests of the public or the administration of justice favors that the accused person be released on bail? And our submission is that the scale doesn't always have to balance. In fact, in some instances, or in most instances, the scale will lean towards one side and the court will decide otherwise. So what we are saying in the case before court is that when regard is held to the seriousness of the charges and the interests of the administration of justice, we are saying the applicant has not shown on a balance of probabilities that he is a good candidate of bail. And we are saying the scales of justice in the current case actually shows or leans in favor of refusing bail to the applicant, in that the interest of justice will be prejudiced if he's granted bail, because he has not shown on a balance of probabilities that he's a good candidate of bail. And when regard is also had to the fact that the ties that he has with another country and the seriousness of the charges will be an incentive or a temptation for him to abscond. We are saying on the reliance of Section 61, the seriousness of the charges and the prospect of a severe custodial sentence to be imposed, we are saying the interests of justice do not permit that he should be admitted to bail. In fact, on page 11, Your Worship, I've referred to the Boyce case, which appears on paragraph 7.5, in which the court reasoned that if an accused is charged with a serious case and if convicted, a substantial period of imprisonment is likely to be imposed, such factor alone entitles the court to refuse bail based on public interest or the administration of justice. So we are saying, on the reliance of the Gustavo case, the Nyipunya case, and the Boyce case, the charges that the applicant faces are actually serious and do not favor that he should be released on bail. And we have referred to other cases in our submissions, which actually appear on, let me just get to the page, Your Worship. Page 10, which is actually the Gustavo case, and also page 12, the Mashuna case, which says that hearsay evidence is admissible in bail application. If it, however, carries less weight, then the court should take that into account. And we have referred to the Charlotte Helena Bota case on page 13, which we invite this court to have regard to. Your Worship, those will be our submissions in short. I think everything else is in our submissions, in our heads, and we will not endeavor to repeat what has been stated there. I think regard must also be had to the facts which actually speak for themselves. Those will be our submissions in short, Your Worship.
Yes, Mr. Isaacs.
If I see it's now 1:08, I want to reply to issues of law. I don't know if we will proceed. It's not going to be long. If I may then do so, and then maybe after lunch, I'm in the hands of the court.
By not long, how much time will you take?
May I say just maybe 10 minutes?
I will allow you to proceed.
Thank you, Worship. Bishop, just maybe before I come to that, my learned friend informed the court that the credit committee, because Mr. Willemse was part of the credit committee, he should have been alerted about the purchase of the APA. But it's a wrong conclusion because the credit committee has nothing to do with the APA. The credit committee simply deals with credit, provide credit of fuel and not purchasing of an asset. I just want to get that proposition clear. Bishop, I also submit that the interpretation of the law in regard to the issue of that the fact that there's a strong case, that alone a magistrate can refuse bail on public interest. That is incorrect, because the court must consider other factors as well. The court must consider how prejudicial will that be for the accused. The court must consider whether or not, even if it's a strong case, whether or not conditions can overcome fears. So simply to say, it's a strong case you will run, it's a wrong interpretation of the law. Simply take that part and say that is the law. One as regard to the cases that I've already quoted in terms of Bolter and Santos. You must also please allow me 1 minute to correct something that has been put to the court. My learned friend says the evidence show that the accused was involved in giving fuel to Irongo for over 238 million. But it is not true. The only evidence that was produced before you was 3 orders, which did not amount to 238 million. So to say that it is a serious case because of 238 million, that would be misleading. My learned friend says also that because of the public interest, I try to understand what his argument was in terms of public interest in administration of justice. If I understand him correctly, he's saying that it's public funds and the strong case. I submit that those are not the only 2 aspects the court are invited to consider when it comes to public interest. In fact, my learned friend's proposition of the law that says that our courts has found that if certain offences falls within Schedule 2, that the court will deny bail. It's not true. It simply says that the court, when these offences fall within the schedule, the court has now a wider discretion. But simply the fact alone that these offences fall within Schedule 2 does not mean, once the court has found that they indeed are in Schedule 2, then bail must be rejected. That is a misinterpretation of what the law says. If the court can just quickly bear with me, please. Which maybe also, it appears to the argument of the state that the accused person bears the onus to provide evidence beyond a reasonable doubt, referring to invoices and the like. But in the beginning, and that's strike law, that the court deal with probabilities. That's the law. My learned friend, in fact, is right to say this is not a trial. So to prove his defense in a trial would expect those documents. But the court must deal with the facts as they are now. There's her statement and there's animals. But to expect the accused person to bring deed of sales, invoices at this stage, I would say that would amount to having a trial. And these issues can be canvassed better in trials. The court must remember that the allegation of ownership of those properties comes from the state. And the law is clear. If you alleges, you must prove. My learned friend cannot just make a bold statement to the applicant and say you own property. They must come say why. And the best evidence before this court in terms of credibility are those emails. Maybe just, I'm sure it goes to the roots, as my learned friends have explained, but there's a fact that my learned friend has missed. The employment of the applicant started actually at CDM, which is in Namibia, in terms of his roots. So his claim that everything happened in Namibia is incorrect. Those were my submissions. Again, my learned friend has not addressed you on conditions. I still don't know why. The court has not addressed you to say that even if the fears are there, it cannot be curbed by conditions. And that is a flaw in the submissions by my learned friend. Because the law dictates that that is something that the court must take into consideration. As the court pleases.
The court will provide its bail judgment on the 28th of October. That is at 10 o'clock.
As the court pleases.
Accused is remanded in custody.
As the court pleases.
We may adjourn.